for the newcomers to the group, I'm Will Satterfield. I'm the Bureau of Workers' Compensation's Division of Safety and Hygiene rep for the Safety Council. But if you have any safety workers' comp related questions, give me a call. So that's my contact information. Feel free to get a hold of me anytime. So, as I have mentioned before, you all can contact our library at any time with questions. Doesn't cost you anything. If you ask me a question I don't know the answer to, I'm calling them. But they get a lot of calls on current issues, bwc.ohio.gov. So, a lot of road construction going on, but just a few tips. We all know motor vehicle crashes kill over 100 people every day. And before you go out, check out your vehicle, check the oil, tire pressure, make sure you use your seat belt. That goes in if you're on a forklift or any kind of heavy equipment. They're equipped with seat belts for a reason. Slow down in work zones. I do a lot of work with a lot of road construction companies, and they're always having people get clipped in work zones. And believe me, that's not a fun thing for the person who gets clipped. If you're going to be drinking, designate a driver, watch your speed, and we all know there's a new law in Ohio on cell phone use while you're driving, so pay attention to that. And that is it for me. So I will introduce, make sure I get this right, Kirsten Schoberg, the Executive Director of the Ohio Disability Rights Law and Policy Center, who is going to speak to us on ADA and common trends in disability rights and access.
Thank you, sir. I'm really glad to be here today. As I was introduced, I am the CEO of Disability Rights Ohio, which is a statewide advocacy organization. We have a brochure that I have put out for you all today if you want to take a look at our website and learn a little bit more about us. Today's training is not about my organization, though. It's going to be a little bit about what's happening in disability law in general. So that's what we're going to focus on today. And I'm going to try to make it as relevant as I can for the types of industries you're in. You're obviously a pretty diverse group. So I did kind of cover a variety of areas of disability law when I was putting this together, but hopefully you will all get something out of the training today. So just kind of start with some disability basics. You may be familiar with some of this, but always good to have a good level playing field. You know, we're going to talk today primarily about disability rights, so we're looking at the definition of disability under the legal standards, under the ADA, under Section 504. We're not talking about qualifying for Social Security disability or veterans benefits or things like that, which are very different definitions of disability. So under disability rights laws, it's a very broad definition and intended to be interpreted very broadly to cover any physical or mental impairment that substantially impacts a major life activity. And I'm not going to get into the real in-depth details of all that legal stuff, but just to give you some examples of how broad it is, it covers everything from PTSD or Down syndrome to cancer, diabetes, someone with physical mobility issues, someone that might be hard of hearing. So it's a very, very broad range of disabilities and medical conditions that would be covered under these laws that we're going to talk about today. Another thing to just generally be aware of is that disability is a really universal experience. Pretty much all of us have a family member or our own personal experience with disability, and if we live long enough, we're probably going to acquire a disability. So it's a very universal experience that many of us have in our lives. And it also, for those maybe who haven't had as much experience with disability personally or with a family member, it can seem very frightening from the outside, but something to be aware of, which is very relevant to this month, which is Disability Pride Month, is that for people with disabilities, that's not the experience that they're necessarily having. Quality of life can be very high. There's a lot of adaptations. The world is becoming more accessible as we break down barriers. And disability is really just one aspect of the person's identity. Just like we all have many aspects to our identity and characteristics, that's how disability is for many people with disabilities. Everyone is different, so I don't want to speak for everyone, but it is, research as well as the experience we have in working with people with disabilities is that it's a part of their life. And I speak to many people that are very proud of having a disability. Again, it's Disability Pride Month in July, and are wanting to make the world a better place for everyone. And many of the adaptations that they fought for benefit all of us. Think of the automatic doors, helps all of us when we have our heavy grocery bags or things like that. Ramps make it easier for parents with strollers. So a lot of the adaptations that have been created in the world for disability access are actually beneficial for all of us. And another thing to think about when we think about disability rights is it again is focusing on breaking down the barriers in society or in the environment in the world around us. And it's moving away from the historical sort of more medical model of looking at disability, which was how do we fix the person? How do we fix that issue? It's focusing on those external barriers. Those are what cause the issues, right? It's not the person's disability that's the problem. It's the fact that our world is not accessible enough that we need to be focused on. So again, this is not going to go into the statutes in any depth. I want to get into issues and examples of what's happening in the world today. But again, to kind of just have a level playing field, there's two main disability rights laws at the federal level that you should be aware of. The first is Section 504 of the Rehabilitation Act, which was passed in 1974. It was the first disability rights protection law. It only applies to entities that get federal funding, so for many of you, it may not be applicable, but if most public entities get federal funding, and then private entities that get federal funding tend to be, maybe nonprofits that get some sort of federal funding, hospitals that are getting Medicare payments, things like that. So it applies to anyone that gets federal funding. And then in 1990, the Americans with Disabilities Act was passed, and that was much broader. So that applies to private businesses that are open to the public, which are called places of public accommodations. And that's, anything from a restaurant or retail business to a doctor's office or a law office or anything like that. It also applies to all state and local government entities. So school districts, police departments, townships, all of those types of things, as well as our state government. And then Title I applies to all employers that have at least 15 employees, so any type of business. So it would apply to, I'm guessing, probably everyone in this room, that you all probably have at least 15 employees. So it's much broader than Section 504 was, but it incorporated some of the same principles. And the purpose of the ADA was to break down those barriers. Congress found that there were a lot of barriers in society that was causing lack of access for people with disabilities, and they wanted to break those down so that people with disabilities could engage in all the same sort of programs or activities that the rest of us engage in every day. And one of the unique things about the disability rights laws and the ADA in particular that's different from like other civil rights protections is the affirmative obligations that it puts on the organizations that it covers. So it's not, you don't get to sit back and wait and see if someone comes and asks for something. You have obligations to take action to ensure equal access to your programs and activities. That could be if you have a physical space, making sure that that's accessible for someone to get in and move around the space, the sort of right-of-way access. And that applies even if your building was built before 1990, if there's a way to reasonably do it without undue expense, so that there is some obligation to make changes to the physical space. And it can apply to other ways of doing your business. A lot of us rely on digital forms of doing our business these days, right? So thinking about keeping your website accessible, things like that are important. The other affirmative obligation that I wanted to point out is reasonable accommodations, which is what we talk about in the employment environment. So that does usually require the employee to first identify and ask for something, but there is an obligation then to potentially make changes to the way you might do things in the workplace so that employee can do their job. And in the local, state government, and private businesses open to the public, the places of public accommodation context, you have an obligation to make what are called reasonable modifications, but many of us just say reasonable accommodations in all of those situations. So if you hear that term, that's what people are talking about. And that's an affirmative obligation, again, usually based on request to make a change to the way you do things to make sure that the person can access those programs or services. So for let's take like a city council meeting that generally you have to come in person to testify or participate in the meeting. They may have to make a modification to that policy to allow phone or some other virtual access. That's probably getting more common post-COVID, but pre-COVID, that was a really hard thing for people with disabilities to get access to. That'd be an example of a modification. And it even applies to some state laws, right? So we've done some work in the area of voting in the past, for example, where the Secretary of State had to change the way they were doing things, even though it wasn't spelled out exactly in state law, that process. They had to change that process to make sure that it was accessible to people with disabilities. So the ADA is a very broad and powerful tool and something that does require all of us who are doing sort of business in this world, whether public or private, to think about accessibility in everything we do. Okay. I want to talk about some common issues as well as some current kind of enforcement trends and some new regulations that have come out as well. So one of the most common misconceptions that we find is around service animals. And I am talking about service animals, not assistance animals in the housing context. So we're just talking about the Americans with Disabilities Act and service animals, which is primarily dogs, because that's really what's common. Service animals are dogs that are individually trained to work or perform tasks for a person with a disability. And some examples, obviously you're, I'm sure, very familiar with the most common one people think of, which is like a C&I dog. But there's many other types of tasks that a service animal might do. They could alert someone who has a seizure disorder that are about to have a seizure, so maybe they can take medication or get in a safe place. They could comfort someone who has PTSD if they're having like an anxiety or panic attack. They can provide physical support for someone that might, have like a tendency to fall over or something like that to help them be more physically stable. They can also help pull a wheelchair or collect items for someone that might be in a wheelchair that needs to, reach down to a shelf or pick up dropped items or things like that. Open doors, all kinds of different things that they can be trained to do. And under the Americans with Disabilities Act, as well as other laws, organizations that have spaces open to the public, whether it's a public or private business, have to allow service animals into wherever you let the public in, right? So if you allow public into that space, the service animal has to be allowed to go in. So, let's take a hospital, because that's something we always think about. If a visitor is allowed back in to see someone who's in a hospital bed, then they have a service animal, that visitor does, they have to be able to take that service animal. Even the patient would be potentially required to be allowed to have their service animal. But we all know operating rooms are different, right? Only the medical professionals get in there. We don't get, the public doesn't get to go into operating rooms. So that's a place where service animals would not have to be allowed to go. The hospital could decide to allow that for the patient if there was a reason to do so. My guess is they wouldn't, though, for various safety and hygiene reasons. But if it is a place that the public is normally allowed to go, then the service animal has to be allowed as well. Restaurants, obviously, is another common place where normally we don't have animals, but service animals would be allowed. One of the misconceptions is, what is required to make a dog a service animal? And it's just that it's trained to do a task. It doesn't have to be trained by a particular professional. There's no certification or registration requirement. Those fancy harnesses that people have, they can have them, but that's not what matters. What matters is they're trained to do a task for a person with a disability. If it's obvious what that service animal is doing, then that should be the end of the inquiry, right? You don't ask any more questions. If it's not obvious, you can ask 2 questions, and that's it. One is the dog a service animal required because of a disability? And what is the task that they're trained to do? And as long as there's an answer given for both of those, you have to take that answer basically at face value, right? You don't get to ask for certification or ask about their disability specifically or inquire any further. If they answer the first question yes, and they provide a task that they're trained to do, that's what is necessary for the law, and you should treat them as a service animal. So that's one of the misconceptions we get a lot, is that people think there's a certification requirement and they deny people access to their organization's space as a result, and that can unfortunately get you in trouble. There was a recent Department of Justice action. They do enforce the Americans with Disabilities Act, and it was a nail salon, I think, and they had denied a customer who had PTSD and a service animal for their anxiety and PTSD to have that service animal in the salon, and they were sued in federal court by the Department of Justice, and not only had to train their staff so that didn't happen again, but actually pay damages to the customer that had been denied access. The only exception is the animal does have to be under the handler's control and has to be housebroken. So under control usually means physical control through some sort of tether, but occasionally someone has a disability where that kind of physical control is not possible. If they're under verbal control, that's okay, but usually physical control is what we're looking for. But if the dog gets out of control and the handler does not promptly correct that, or they're not housebroken, you can ask them to remove the service animal from the premises. But that's the only situation. I think you could probably answer these questions in that way and maybe slide under the radar there. But the intent is to try to make sure that we're not unnecessarily denying access to people, right? And occasionally there could be someone that goes beyond what maybe the intent was. But again, we're trying to break down those barriers, and if they are trained for a task for the person's disability, then they are a service animal and have to be allowed in places that are open to the public, as long as, again, they're within the handler's control and housebroken. So those are the important aspects. But yeah, it is much broader. They have clarified some of this over the past decade. There's been additional regulations that have come out around it and really separated service animals as dogs and that are trained, and occasionally miniature horses, but again, we're not going to talk about those today, from what might be protected under the Fair Housing Act, which is very potentially different, right? Assistance animals are a whole different beast. So if you hear someone in the news talk about a service animal is like a cat or a chicken, they're not a service animal, okay? They might be an assistance animal and they might be allowed in the person's home, but they don't get protections in the place of public business. There are exceptions, obviously, for air carrier traffic, but we're not going to get into those today. There's different requirements that have to do with transporting animals, but they're not service animals unless they're a dog trained to do a task. And sometimes the language gets a little confused in the media and news reporting. Any other questions about service animals? Yeah.
I know there are a lot of laws where they tell you on your front door that you have to post things. Are we required to post service animals welcome, or is it just assumed?
That's a great question. I'm not aware of any requirement that you need to do that. I would say that if you have something that says no pets or no animals, that you should add except service animals, just so that people understand. I would just say that would be a best practice to avoid any appearance of exclusion. But I don't think there's a requirement to have any particular type of sign. I would say training your staff would be a great idea, right? The ones that engage with the public, to make sure that they are not denying people access inappropriately. Yeah, great question. Yeah.
Were you going to talk about emotional support animals?
I'm not, because that's under the Fair Housing Act, and I was not going to focus on the Fair Housing Act today, which mostly applies to housing, right? I mean, a small dog can be a service animal. If they are trained to, for example, comfort someone with PTSD during an anxiety attack, that's a service animal. Some people might think of that as an emotional support animal, but it is trained to do a task. So I would just encourage you to, err on the side of asking the questions that you're allowed to ask. And if you get an answer that is, satisfactory, that yes, it's for a disability and it's trained to do this task, they have to articulate a task, of allowing them access, because I think you, run the danger of actually discriminating against someone who has a legitimate issue and putting yourself at risk of liability. And will someone potentially, again, get in when maybe they shouldn't have? Maybe. But if the dog's under control and housebroken and they've answered the questions, the safest route for you is a either a business owner. And there's a lot of misconception about disability needs and what service animals can do, and invisible disabilities. And so I would just encourage you to rely on what the person says as much as possible, because generally speaking, there's so many people with disabilities that are being discriminated against because they're not believed, that it would be better to give that benefit of the doubt, as long as they're providing the answers to the questions when it's not obvious. So, yeah, great. All right, I'm going to move on to effective communication, which is another really important aspect of the ADA that applies to, I have Title II and Title III up here, and that's Title II is local and state government, Title III are those places of public accommodation. So effective communication is this idea that the communication you're having with your customers, with the public, should be as effective for people with disabilities as it is for someone without a disability. And the key to deciding what's necessary or what's effective communication really comes down to what is the type of communication. So there's a difference between a sort of temporary, kind of more intermittent interaction you might have with someone and a longer, more complex conversation. So if you let's take like a restaurant example. If someone comes in and they usually speak with American Sign Language, you're not required to have an ASL interpreter or get a video interpreter to help them order their food for the day, right? Or ask questions about the menu. You can use notes or hand gestures or any other method that would help you communicate with that individual. However, if you're sitting down, maybe going over like a contract with a customer for some sort of engagement, or it's a doctor's office where they're having a medical appointment, or you're doing an intake for services or something like that, something more complex, a longer, more in-depth conversation, then you're going to need to do something that is going to be more effective, like getting an ASL interpreter if that's their form of communication, for example. For government and state and local government entities, you actually have to give what's called primary consideration to what the person selects as their best and preferred method of communication. And unless there's some undue hardship or undue expense, you have to honor that request. For the places of public accommodation, you're encouraged to strongly consider that, but you don't have to give it primary consideration. But again, at the end of the day, the goal is effective communication. You might need to have a little bit of a sort of interactive conversation to figure out what's going to work with your business and with that person to meet those needs. This is another area where there's been a couple of recent Department of Justice enforcement actions around effective communication. One was a school district where the students who needed ASL interpreters were being sent all to like a cluster school. They were, instead of going to their regular school in a regular classroom, they were sent to a cluster school and classroom so they could kind of group them together with like an interpreter. I'm assuming it was probably a cost-saving move. That's not okay under the ADA, right? Effective communication has to be provided to the person in this case under, there's other laws that come into play as well, but in their sort of most integrated setting, right? Where you would otherwise provide programs or services for anyone else. The other action was a hospital that didn't provide qualified interpreters for deaf individuals, and they settled the case and, of course, had to do new policies and new training. And again, they had to pay damages to the patients that were impacted. So it is something that the Department of Justice does take very seriously as well. All right, I'm not going to spend a lot of time on this because I don't think it's as relevant to a lot of your work, but it is also this month, the Olmstead anniversary. If you're not familiar with what that is, it was a Supreme Court case from 1999 that interpreted the Americans with Disabilities Act as requiring providing services in the most integrated setting. And it's primarily been relied upon to deinstitutionalize individuals with disabilities and work on expanding those home and community-based services. But it's also starting to be expanded to employment supports where people are, maybe being in segregated employment as opposed to more integrated options. So it's been broadened over the years. A recent DOJ example that is in a hospital setting was that they were unnecessarily keeping children that had mental health needs in the hospital longer than they should have been, like they were ready to be discharged, but they didn't have the community supports necessary to provide them in the community. And they were therefore not, because of those lack of placement options, they weren't being discharged and were unnecessarily segregated. This is a school setting related case which focuses on the ADA as protections. There is a whole other set of laws that we're not going to talk about today, which is the Individuals with Disabilities in Education Act. But the Americans with Disabilities Act applies to school districts as well. And the Department of Justice has more recently been enforcing the ADA in schools to, again, focus on this, some of the concepts of things that are protected by the ADA that might be potentially even broader than the IDEA at times. And this is from 2024. And a school district had been involving law enforcement to remove students from the school. They were sort of informally, without following the regular process, removing kids by calling their parents and saying you have to come and pick them up, halfway through the school day, but they weren't marking that as some sort of a suspension or going through the counting of days or process that you have to do for that. And the Department of Justice settled with that school district in 2024, and it requires them to make sure those informal removals are not happening, and to engage an outside behavior support consultant to help them build up the supports that they need within the school to help these kids that had behavioral health needs that were being excluded because of that disability-related behavior. They had to revise their student code of conduct so that it included positive behavior supports and limited the use of law enforcement to appropriate situations, instead of, sometimes there's sort of very draconian steps that can happen in a code of conduct. So they had to make some changes to that to make sure that it wasn't going to exclude students that had a disability related behavior that needed supports within that district. I don't know how many folks are in the healthcare business here, probably not a lot, but I do still want to touch on the fact that there are some new regulations under Section 504 of the Rehabilitation Act. They're regulations by the Department of Health and Human Services, so they are primarily focused on medical situations, but there are some applications to things like child welfare and foster children and things like that. But I think it's important to be aware of because there's going to be more focus on making sure that we're having access in all of these different places, and you might expect similar types of regulations to come down from other agencies in the future. So some of the key provisions is making sure that there's digital accessibility. So I don't know how many of you have gone to the doctor's office, like especially bigger places. I went to OSU, not the hospital, but like a separate doctors type OSU place, and they have these kiosks for you to check in, right? That's becoming really common for larger settings. That's making sure that those are accessible for different types of disabilities, vision, hearing, things like that is one of the requirements. Another one is requiring accessible medical equipment. So a lot of times if the exam bed is not adjustable, it can be really difficult for some individuals with disabilities to just even get to a primary care doctor to have an appropriate physical exam. Scales, if you don't have a wheelchair accessible scale, that can be really problematic for people, again, for primary care or any kind of medical care. So they're requiring accessible medical equipment. Another really important one, and this actually came out, you might have heard, in fact, some in the news during the height of the COVID pandemic. There was a lot of concern about the way that services might be triaged, that there would be discrimination against people with disabilities. These regulations take some of the guidance that they put out during that time period and made it part of the permanent regulations, that you can't discriminate in the sort of provision of the type of medical care that you're offering or decisions about medical care based on assumptions or views about the quality of life of the person with a disability, because that's a lot of what was happening. And they actually specifically banned some assessments that have the danger of bringing in that sort of subjective quality of life perspective that individuals might have. So, for example, a lot of people in the public and in the medical field might believe that if someone is using a ventilator in their daily life, that quality of life is lower, and they might treat them differently in deciding whether they should get an organ transplant or be prioritized for treatment when there's scarcity of resources like there was during the beginning of the pandemic. And so they made it clear that you can't discriminate in making healthcare decisions in that way. And then I mentioned that it applies to child welfare. So it prohibits discrimination on the basis of disability of the parent There's actually an Ohio law that does that as well, and I would argue the ADA always did that, but they've made that clearer in the regulations, and it's always helpful when there's some clarity and additional sort of, I guess, focus on an issue that is problematic in society. All right, another important area in general is accessibility. So we have physical accessibility. We talked about, the requirement to have your buildings or physical places accessible for someone that might use a wheelchair or a mobility device, as well as digital accessibility being really important. And it's definitely an area that the Department of Justice has a lot of programs. Sometimes they are enforcement, but sometimes they also have programs where they can work with cities to help them identify, development needs, help with planning, and things like that to make sure that there's accessibility throughout the programs for the entity. One of the new things that's going on right now is it just became effective in June, the DOJ web accessibility rule. So clarifying what's required under the ADA for your websites if that's part of your business model. And there's been this, I don't know how many are familiar with the web content accessibility guidelines called WCAG. This may not be your area of expertise in your business, but if you have someone that is in charge of your website, asking them, are they paying attention to these new guidelines? WCAG's been around for a long time, like the actual guidelines have been around, but the requirement by the DOJ that you comply with those as part of complying with the ADA, that's what's new with these regulations. And for public entities, there's two different timelines for implementation. If you have a population of more than 50,000, you have 2 years to fully implement the new requirements. And if you have a population of less than 50,000, you have 3 years to fully implement. So they gave people a little bit longer, and there is obviously a time period to implement, because we all know, we heard about the website problems that you were talking about earlier. It's not always easy to fix these things, so they want to kind of balance the needs of accessibility with the realities of business and technology. But some of the key provisions are, making sure the information is presented in a way that all users can perceive it, right? See it, hear it, whatever the way that they might perceive it. Some examples are a thing called text alternative or for non-text content. So sometimes people call that alt text. You may have heard that phrase before, but if you have graphics or video, you want to make sure you have text alternatives to that non-text content. It requires captions for all pre-recorded audio content, including in videos. So, to make sure that we're having accessibility for people that have different types of disabilities. Screen reader accessibility, that's where someone that is blind or low vision or maybe uses some other type of technology to read the content on a screen. That's another important aspect of these WCAG standards, to make sure that screen readers can go through the information and that it's tagged and in the right sort of order. I don't expect you guys to be technology experts. I'm not one either. I just want you to be aware that this is out there so that you can maybe let the folks in your business who are responsible for that know that this is a new thing to be paying attention to, and make sure that you're coming into compliance with it. There was some data that said that 96% of all the world's websites currently have some failure to comply with the WCAG standards. So it's pretty common to have issues out there, right? So we have a lot of work to do. But on the positive side, there's been research around the benefits of increasing your digital accessibility, the benefits for your business and your organization. There was a 2023 survey of 1,000 decision makers in U.S. businesses, and they talked about all the benefits to their business of increasing digital accessibility, such as consumer satisfaction and repeat customers, and obviously all of this impacts the bottom line, right? It's going to help with your revenue and your profitability. So 85% said digital accessibility gave them a competitive advantage and helped them tap into maybe a business that was underserved, or just, again, we talked at the beginning about how when you make things more accessible for people with disabilities, you're often making it more accessible for the rest of the world and more user-friendly. So those digital accessibility adaptations can be beneficial for everyone. Another exciting thing that's business driven right now that I actually found out about in reading a news article is Yelp is adding features related to accessibility in their reviews and search functions so that people can now search better for like wheelchair accessible entrance, no step, ASL proficient if you have like a staff person that is ASL proficient that deals with the public or something like that. And I'm not sure exactly how it's going to work, if businesses can put that information sort of in their profile or if it's going to be based on user experience or both. But I think it's really cool. I think it could really help with making the world more accessible and getting businesses to think more about accessibility, because now it's part of the conversation, right? It's not an afterthought if we start thinking about it as part of the customer experience for everyone. The last thing I want to touch on, which I also think is very exciting because while it is statewide and in fact part of a national movement, the organization that's really been driving it is here in Montgomery County, and that is Universal Changing Tables. You may not know what I'm talking about, but some adults with disabilities are going to need to have toileting and changing of different incontinence devices and clothing and things like that when they're out in the public. And the changing tables we have for infants just aren't going to work, right? So universal changing tables are about trying to make public spaces more accessible for people with disabilities so that they don't have to choose between using the bathroom and going out somewhere. And so that's what this is all about. And it's really cool. It's an advocacy push to address this unmet need. There was funding, I believe, in the last state budget, and organizations can apply for funding through their local County Board of Developmental Disabilities. They have grants. If you want to know more about it, I encourage you to check out the Changing Spaces Ohio chapter webpage to learn more about this. If you're interested in, if it's appropriate for your business or your organization, and you're interested in learning more about it. But I think it's really cool. It's a grassroots-driven effort to try to make the world more accessible for people with disabilities in an area that a lot of us take for granted, right? When we go out somewhere, that we'll be able to go and use the restroom if we need to, and that's not necessarily true for a lot of adults with disabilities. We as a statewide disability rights advocacy group, we're always interested in trying to make the world a more accessible place for people with disabilities, and through education is one of the ways that we can do that by raising awareness. So I'm glad to be here with you all today.